Well, it's been almost 2 years since Governor J.B. Pritzker signed into law the Protect Illinois Communities Act, but after court hearings and filings and thousands of pages from the states trying to defend the law and plaintiffs saying it violates the Constitution, Illinois' gun and magazine ban has been struck down on final judgment in the Southern District of Illinois Federal Court, but the judge in this case, Stephen McGlynn, putting a 30-day stay on that. That was issued Friday, and we've got reaction from all around dealing with this, including from the Federal License Firearms of Illinois here in Illinois. We've got an individual speaking up to this. Also, we've got the pro-gun control group saying that they expected the ruling, but let's go through the ruling in some detail here. And you'll be able to find this at thecentersquare.com. And if you follow me on X, you were updated Friday as this happened. But attorneys for the state filing a notice of appeal with the federal district court that found the state's gun and magazine ban violates the Constitution. So obviously, Friday, the ruling was made, and the state then went ahead and, filed a notice of appeal on Friday. Have yet to see it actually pop up on the appeals page, but we'll be tracking that. But back to the original headline here. Federal judge declares Illinois' gun ban unconstitutional, stays for 30 days. The Protect Illinois Communities Act is an unconstitutional affront to the Second Amendment and must be enjoined, according to Judge Stephen McGlynn, in that 168-page ruling, and you can link to it there. He goes on to say that the government may not deprive law-abiding citizens of their guaranteed rights to self-defense as a means of offense. The court will stay the enforcement pending 30 days. And again, in the background, January 2023 is when Governor J.B. Pritzker signed the measure. It was during lame duck session in 2023. Lawsuits filed shortly thereafter. The state argued that the banned firearms are too similar to military firearms. They're dangerous and unusual, and banning them is for public safety. But plaintiffs say banning commonly owned firearms violates the Second Amendment right to keep and bear arms. So you had those four consolidated cases, and just to, again, the background here I think is important because hopefully it helps educate people on how these types of cases work and how they feed through the courts. You've got the preliminary issues that were handled in April of 2023. Judge McGlynn in the Southern District issued a preliminary injunction because the plaintiffs were asking for an initial halt of the law while the case proceeded on the merits. So it's almost like, an initial request. They filed the lawsuit to block the law on the merits, but before they got to the very lengthy discussion about the merits, they wanted a preliminary blocking of the law. So an initial blocking of the law. They got that in April 2023, lasted for 6 days before the appeals court came in and essentially held that ruling at bay while they heard the case and then ultimately sided with the state on preliminary grounds. These cases even went all the way up to the U.S. Supreme Court with a request for the justices to take the case on preliminary grounds, but because it was not fully vetted, was not on the merits, the U.S. Supreme Court said, no, bring us back a case that's fully developed. So that's what happened in September with Judge McGlynn on final judgment having that 4-day bench trial, and we covered that quite a bit. So clearly, after that 4-day bench trial, there was some indication of where McGlynn was going to go, and the court came out and putting out their ruling on Friday. The case, back at district court, 4-day bench trial. After final briefs are filed, McGlynn's ruling came out and said the court's not convinced that weapons like the AR-15 and its relatives are dangerous and unusual. He also criticized the state's prohibition on limiting magazine capacities, saying that these devices are also in common use and have legitimate self-defense purposes. For magazines, every round matters in a defense scenario. Reloading takes away significant time, during which the defender can be injured or wounded. When the preliminary issues were debated, you had the appeals court essentially side with the state and say that they're too similar, but McGlynn pushed back, saying that idea of AR-15s being similar to military firearms doesn't really hold water. He says the court holds military use refers to weapons that are selected, procured, tested, and issued to military members for use in combat. With that in mind, none of the weapons, magazines, or attachments prohibited by PICA can be called military grade since they were not issued to the military for use in combat. He goes on to talk about, the pushback from gun control advocates who say, well, what about mass shootings? He says, while the court's sympathetic to those who've lost loved ones to gun violence, such tragedies are not an excuse to restrict the rights of the Illinois public as protected by the Second Amendment. So you can read more about that. Obviously, a big ruling. I talked with Dan Eldridge from Federal Firearms Licensees of Illinois. He also owns Maxson Shooters Supplies in Des Plaines, and he said, "Yeah, this is a big win for the gun rights community."
Obviously, we had a big win during the trial. The state put forward a pretty limp defense of this thing. We had the stronger expert witnesses. We had the facts on our side. This decision is 168 pages of just simple fire. I have not been through all of it, but there's definitely some real nuggets in here. It's a victory that has an expected downside for us, which is that Judge McGlynn stayed this injunction for 30 days, providing the state a window to appeal. So the stay means, of course, that the state is not enjoined from enforcing this so-called assault weapon ban for 30 days. They have 30 more days to file an appeal, and they will probably look for and get an emergency stay from the Seventh Circuit Court of Appeals.
So in my conversation with Eldridge Friday, we talked a bit about what that could possibly look like, especially since, you've got a question of one of the three panel on the preliminary ruling is no longer there from our understanding. Judge Diane Wood is not there. So what happens? We'll see, but other details of importance that Eldridge pointed out from the ruling.
Well, I think it's something that's important to focus on here. I don't have the page number reference, but he rejected the notion of severability, and I'll read you from his opinion. This court also recognizes that Illinois' definition of, quote, assault weapons, close quote, may be referenced elsewhere in statutory scheme, and future legislation may be passed that does not offend the Second Amendment. However, this court is unable to determine a reasonable way to sever the offensive portions of PICA such that what remains would have been enacted by the legislature or operative as a law. Therefore, this court holds that the operative provision of PICA cannot be severed from the whole and must be stricken in its entirety. So in other words, he's knocked out severability. You're not going to be able to pick and choose which provisions are reasonable and which are not. And frankly, this is a bit of a rake that Judge Easterbrook and Wood stepped on in staying our preliminary injunction, where their whole argument was built around an AR-15 is the same thing as an M4 or M16. Well, number one, no. Number two, what about all the other prohibited items, all the prohibited shotguns, all the prohibited handguns? You can't just sever that out and say, okay, yeah, we were wrong there. So it's a big decision. It's a big win. It's 168 pages of solid record that the Seventh Circuit is going to have to contend with. So now we go back to the Seventh Circuit. If they're in session, it'll go to, I believe, an appeals panel directly. If it's not, there will be a motions judge who handles the traffic coming in and would likely grant a further stay, emergency stay. And then it'll go to another three-judge panel. Our last three-judge panel was Easterbrook, Brennan, and Wood. Judge Brennan issued a very strong dissent in our favor. Judge Easterbrook and Wood obviously came down against us. Judge Wood has since resigned from the court. She didn't just take senior status, she's gone. So we'll have to look at the rules of the Seventh Circuit and the Court of Appeals and see how they go about replacing a judge on a three-judge panel, or if it's a completely new panel that's created. We're canvassing the members of the Seventh Circuit just to see what the odds look like. But the reality is that's just busy work because it doesn't really change the outcome. But I think that right now the existing panel is split 50-50. Also, Judge Easterbrook left open the door for being convinced that an AR-15 is not the same thing as an M4 and an M16, and I think we did that. And I think that Judge McGlynn made a powerful argument that that's a nonsensical standard.
And again, in the conversation I had with Eldridge on Friday, he highlighted that. And if you go through the actual, arguments there, the arguments that modern semi-automatic firearms available to the general public are too similar to firearms used by the military. The judge in this case, in the district level, said that doesn't match precedents from the U.S. Supreme Court or the record developed during the 4-day bench trial he oversaw in September. He said, critically, the M16 and M4 are military-issue weapons subject to the specific standards of military specificity and rigorous quality assurances and inspections. The AR-15, by definition, cannot and does not have the same standard of quality assurance. Notably, M16s, M4s are designed for increased wear and tear and have a barrel that is capable of sustaining fire without overheating. And that was something, again, they had the experts to discuss that. But gun control advocates, they expected McGlynn's ruling. Here is a statement from John Schmidt from GPAC, said Judge McGlynn's decision to again enjoin the Illinois ban on assault weapons and large capacity magazines is completely predictable. He did it before the statute passed in early 2023. In remarks from the bench in September hearing, he made clear that he would do it again. Closing that bench trial in September, McGlynn reflected on the 1917 race riots in East St. Louis and asked what would have been different if black victims there had the types of firearms being debated in the case. He further wrote about the issue in the order that was issued on Friday. To limit civilians' choice, quote, of arms would tip the scale in favor of the aggressors who already will likely have various technical advantages, including the element of surprise. So McGlynn wrote in his permanent injunction that he sympathizes with those who've lost loved ones to gun violence, but such tragedies are not an excuse to restrict rights guaranteed to the Illinois public. Eldridge essentially agreed with that sentiment, saying that you don't do that with anything else in society.
In no other context do you hold the law-abiding responsible for the depraved acts of deranged individuals. It's as simple as that. And you can just stop the argument right there, which I think is what he's saying. You just can't do, there's no other instance in which we would do that in this society. Drunk drivers, and you don't create calls for banning automobiles or banning alcohol. These are illegal acts. They are depraved acts, and they're criminal. And it's criminal violence, and any right-thinking person condemns criminal violence. But the point is, and the point of Heller and Bruin, is that these firearms are in common use by law-abiding people for lawful purposes. And that's where the argument ends.
Finally here, in the conversation I had with Dan Eldridge from Federal Firearms Licensees of Illinois, we talked about some other elements in here. The FFL of IL, they really were focused on parts and being able to repair and the right to repair. But he also talks about the next steps in this legal fight for Illinois' case, which is apparently going to be going to the appeals court because the state has indicated through a filing in the district court that they plan to appeal. So that has been filed. We'll see what the appeals court does. But come December 8th, that 30-day window of the stay, if that comes up and there's no other stay the appeals court issues, it's the state's enjoined from enforcing the law. So let's hear a little bit more from Dan Eldridge.
Well, and one more thing is that our lawsuit, that being Federal Firearms Licensees of Illinois et al., one thing that we had, and we had two things in our suit that were unique in all of these efforts. Number one is right to repair. So if you can't buy parts, if you can't replace broken attachments for your registered firearm, if you chose to comply, then by way of attrition, you're just going to attrit away the entire supply of these firearms, even if they are compliant with the law. And the other thing that we attacked that I believe he touched on here was the registration scheme and the unconstitutionality of that. So, yeah, big win across the board. And I'm more optimistic than most of the people on our side that we may even get a favorable ruling out of the 7th if we get there. All eyes now turn to the Supreme Court and whether or not they're going to hear the Snope case, which is the Maryland assault weapon ban, formerly Bianchi. Mr. Bianchi had quite enough of Maryland and moved out, so there's another plaintiff named here. If the Supreme Court hears Snope, I would expect all of this litigation to be paused pending the decision by the Supreme Court, which we would have by June, July of next year. So it's a win. It doesn't change anything for Illinois gun owners right now because it is stayed for 30 days. But I think there's a high likelihood that either the Supreme Court rules in favor of the plaintiff in Snope and knocks out Maryland's assault weapon ban, or probably a better than even chance that we win in the 7th Court of Appeals. And if we win on the panel, I don't know that the state would appeal to the Supreme Court or go en banc with it. They would do the same canvassing that we're doing to try to figure out whether that's prudent or not. But just as happened with concealed carry, the state chose not to appeal to the Supreme Court because they didn't want Illinois to be the state that set the precedent nationwide that you just simply can't do this.
So clearly, some interesting thoughts there from Dan Eldridge, federal firearms licensees of Illinois, and what the next steps are in this case. We'll be watching it, obviously, as we have the motion, the announcements that the case is going to be appealed, being filed to the district court. That has yet to be recognized by the appeals court. I'm just checking here. But something else that's going on today, and we will talk more about this tomorrow. That is the case of Cuberto Viramontes challenging Cook County's ban. And that is actually up in the appeals court today. So let's take a look at where we're at with that. Obviously, you'll be able to follow along with the 7th Circuit U.S. Court of Appeals in that case, as you've got Viramontes versus Cook County going to oral arguments today. So if you find the 7th Circuit U.S. Court of Appeals in the YouTube world, you'll be able to watch and you'll be able to listen to that live. But that is set for today in federal court, in the appeals court. And let's take a look at the docket here. Obviously, some latest filings that were filed yesterday. Firearms Policy Coalition, Second Amendment Foundation. You've got them filing a brief here. Pull it up. It's about 168 pages and includes the Barnett opinion. So clearly that's something that I think is going to be added to the conversation today in the appeals court. So they've attached the Barnett opinion that was released on Friday. And the Cook County defense, they filed 3 pages here. 3 pages yesterday they filed. Let's pull this up. It just talks about the response letter submitted and the problem with the Barnett. It's unpersuasive on its own terms. Just reviewing this myself here for you before we head into this case. Says that this is most obvious in its definition. Common use is whether a firearm is or has been available for the purchase, possession, and usage by law-abiding citizens for self-defense. This test is wholly disconnected from the undisputed historical understanding of common use as required in inquiry whether it's usual to be armed and clad with a weapon. So it's also bizarre, Cook County argues, under that definition, a gun is commonly used if it has literally never been used for anything but merely sat on a dusty store shelf available for purchase. That is light years from the historical understanding of common use and even farther from common sense. So again, that's just a preview. Those were filed yesterday, right? So the plaintiffs in the Viramontes case heading to the appeals court for oral arguments today, saying, hey, here's the Barnett opinion that was out of the Southern District. And then the Cook County defense coming in saying, no, this is absurd, it's a bizarre argument. So we'll obviously review all of that here tomorrow with Illinois in Focus Daily. Wake up each and every weekday morning with us. Get the latest of what's happening here in Illinois. Like, subscribe, hit that notification bell. America's Talking Network, and get the podcast anywhere you get podcasts. Here with Illinois in Focus Daily.